So your girlfriend got a restraining order against you, and now a week later, she wants to meet up and she's changed her mind about everything. The question is, can you meet her because it's mutually agreed, even though there's a restraining order? The short answer is no. My name is Darren Woodfork, and I'm an attorney here in Scottsdale, Arizona. I've been practicing law for 26 years here. In the early part of my career, I did a lot of criminal defense work, and we've did a lot of restraining order cases, and we defended violations of restraining order cases here. And today I want to talk about what the strange law is, I guess, here in Arizona, and how it's so kind of like strict liability. Because I mean, you want to know if somebody gets a restraining order against you, but yet then they change their mind and they want to initiate contact with you. You would think that you could do that, but you can't. In Arizona, even if the victim initiates contact, it's still a violation of the restraining order. And so understand that you can't have a mutual uh, meeting, I guess, with the victim. Um, and it doesn't have to be like a physical meetup either. It could be like text messages. It could be like indirect calls where you have somebody call on your behalf to the victim. Or, even if if the victim has somebody else call you or text you or anything like that, those are all technical violations of the restraining order, and the judge will pursue those. And also, it's like it doesn't. I mean, the judges are the more concerned about the black letter of the law, or like I said, the strict liability, and they really don't care about the facts of the case. And again, you would think that there'd be kind of like some common sense involved here, but there's not. They're just like, again, if it's a technical, if you made contact with the person who took the restraining order out against you, then you're in violation of the restraining order, period. I remember there was an instance years ago where the girlfriend basically took out a restraining order against a guy, and then I think a couple weeks later, they had to exchange a diaper bag for the kids. And once the defendant went and exchanged the diaper bag, the victim filed a motion saying that the defendant violated the restraining order, and the judge upheld it, or the judge basically convicted the person of violating the restraining order and put him in jail. And again, for the exchange of the diaper bag for the kids. Again, that's just an example of how strict liability or draconian the law is when it comes to restraining orders. So the bottom line is you can't make contact with the person who took out the restraining order, even if the person who um, initiated. Again, if you're in that situation, I guess the best thing that you could do is just to document it really good, as far as like all the contacts that the victim had with you and how they initiated and things like that. Again, you that would be like your best defense in that situation with the judge. So. Anyways, hope that helps. Like I said, that's one of those things that's kind of surprising in the law, that you would think that, well, if she initiated contact, how can I be guilty of violating the restraining order? But sometimes that's the upside down world of the court system. Again, my name is Darren Woodfork. If you have any questions, please leave them in the comments below. And please like the video and subscribe to the channel. Thanks.